So let's resume from Article 25. We have completed till 24 in depth. From 21 itself, I have given all the judicial developments also. So view the previous videos. Subject to public morality, all this you know. I will discuss this other provisions. How these other provisions affect this right and how those other provisions can sometimes subdue this right. Okay. Also, this particular thing. The state can make law in religious matters also, but only those things which are secular in nature in that religious matter. Okay, let's see the nuances of it. Article 25. This is an individual right, always remember, and 26 is a collective right, also known as a group right. Okay, this part, other provisions of this part, and we are dealing with the part 3 of the Constitution, that is fundamental rights. Okay, so specifically, right to equality, life with dignity. That is life and liberty, but we have in-depth study of this Article 21. So now we know dignity is more important than just existence. So in any case, if this particular thing, right to profess, practice, freedom of conscience, etc., is violating equality, and also remember equality among the equals. See the 14th Article 14's video if you are not clear about this. Equality is not a universal concept. Equality among the equals. Okay, reasonable classification by the state is allowed. So see this. If these two or any of these one is in violation because of this Article 25, automatically this can be subdued. Now we will see the judicial development. In this particular Tirur Mutt case, what we will see, the Supreme Court of India came up with this ERP doctrine, that is Essential Religious Practices Doctrine. Okay, and who will decide this practice is an essential religious practice? It is the judiciary. But this creates a paradox. Should the judiciary decide this or not? This is part for the mains. Okay, a three-step process to test whether this particular thing in that religious practice, that practice is a ERP or not. How will they decide? They will decide by first looking into the tenets, that is fundamental text of that religion. Then alteration fundament. Okay, so alteration means changing. So if that particular religious practice is taken from away from that religion, will that be affecting the whole nature of that religion? If yes, it becomes a part of ERP. If no, otherwise no. Superstition versus religion, and those matters which are absolutely only related to superstitious beliefs, the Supreme Court can say that that is not part of ERP. Okay, secular superstitious part can be regulated by the state. Remember this line. Now we will look into Article 26. It is not an individual right, but it is an collective right. Remember this. Okay, also this is for autonomy in managing their religious denominations. Who will decide whether it is a denomination or not? We will see that also in the judicial test. Collection of individuals with common belief system first. Second is common organization, and third, they should be designated by a distinct name. Okay, then that thing becomes a denomination. Sometimes, for example, in certain books, like in Lakshmikant, there was written Ramakrishna Mission. So those are not denominations; these are subsets or sects under the denomination, larger one. Okay, religious autonomy, but in administration of property, state can check if the procedure is just. Very important line. Okay, these denominations have 100% right to administer their stuff, but while managing the property, the state can check whether this is just or not, this is fair or not according to the law. Only this, not the religious matters. Okay, Article 27 prevents theocracy. You can see the text for this. Okay, pause the video and see. Now we will see the important parts or aspects of that. What is theocracy? Rule of religion. Not favoring any one particular religion over the other using the public money. Remember this line, not favoring any particular religion using the public money. So state cannot say that we will favor only this religion or that. Also, the state cannot impose any tax, but they can impose a fee. Tax is invalid, but fee. But there is a reasonable restriction here also. That fee can only be used for, fee can be taken for specific purposes like health services, security, sanitation, etc. It is also not arbitrary in nature. So in our system, arbitrariness is never allowed. Everything is there in the constitution itself so that the state does not become very powerful. Okay, that's why this constitution of ours is a very beautifully written constitution and the, I think, the longest written constitution. Okay, so now we will discuss Article 28. I'll not go to the text because you have all the access to that. We will discuss the judicial development related to Article 28. Okay.